Hiya, it's Neil here. Today I am going to explain the meaning behind some of the legal words and phrases that we see all the time but do not necessarily understand. 1. Plaintiff. A plaintiff is the person who starts a civil court case because they believe someone has harmed them or owes them something. For example, a customer is injured when a supermarket shelf collapses. If the customer sues the supermarket, the customer is the plaintiff. 2. Defendant. A defendant is the person or organization against whom a case is brought. In a criminal case, it means the person charged with committing the offense. In a civil case, it is the person being sued. For example, if someone is charged with the theft of a bicycle, that person is the defendant in the criminal case. 3. Applicant. An applicant is someone who asks a court to make a decision or order. For example, a non-custodian parent might have to apply to the district court for an order allowing them to spend time with their child. That parent is the applicant. 4. Respondent. A respondent is the person who must answer an application made to a court. For example, if the custodian parent does not want the other parent to have access to their child, they can oppose the application. This makes them the respondent. 5. Proceedings. Proceedings are the court case and all the official steps connected with it. For example, filing documents, attending hearings, giving evidence, and receiving the judge's decision are all parts of the proceedings. 6. Cause of action. A cause of action is the legal reason why someone is entitled to bring a civil claim. For example, being annoyed with a neighbour is not normally enough to bring a case. But if the neighbour deliberately damages your car, that damage may give you a cause of action. 7. Liability. Liability means being legally responsible for something. For example, a driver who carelessly crashes into another car may be liable for the damage. This means the driver, or usually the driver's insurer, may have to pay for it. 8. Negligence. Negligence means failing to take reasonable care and causing someone to suffer injury or loss. For example, a cafe employee washes the floor but does not put up a warning sign. If a customer slips and is injured, the cafe may have been negligent. An accident does not automatically mean that somebody was negligent. It is often a question of whether the behavior of the defendant was below a reasonable standard. 9. Damages. Damages are money awarded to compensate someone who has suffered an injury or loss. For example, if a person is injured in a road accident as a result of somebody else's negligence, damages might cover medical expenses, lost wages, and compensation for pain and suffering. Here, Damages means money. It does not mean the physical damage itself. 10. Remedy. A remedy is what the law does to put a problem right. For example, a shop sells you a faulty product. Depending on the circumstances, the remedy might be a repair, replacement, or refund. In court, a remedy might include compensation or an order telling someone to stop particular behavior. 11. Burden of proof. The burden of proof tells us who is responsible for proving something. For example, if a teacher claims that a student copied homework, it should be for the teacher to support that claim, not for the student to prove that copying never happened. In a criminal case, the prosecution carries the burden of proving that the accused person committed the offence. 12. Balance of probabilities. The balance of probabilities is the usual standard of proof in a civil case. It means that something is more likely to have happened than not. For example, two students each claim that a football belongs to them. After hearing both stories, a teacher decides that it is more likely than not that the football belongs to one of them. It can be imagined as the scales tipping slightly in one person's favour, but what is more important is to understand what can be put into the scales in the first place, as well as what needs to be kept out of the scales when weighing. 13. Beyond reasonable doubt. Beyond reasonable doubt is the very high standard of proof required before someone may be convicted of a criminal offence. For example, finding a missing chocolate wrapper in a student's bag may make people suspicious. However, another person could have put it there. More convincing evidence would be needed before deciding that the student stole the chocolate. The prosecution does not have to answer every imaginary possibility, but the jury must not have a reasonable doubt about guilt. 14. Without prejudice. Without prejudice is commonly used during genuine attempts to settle a dispute. It can prevent settlement offers or admissions from being used against a person later in court. For example, two neighbours disagree about a damaged fence. One writes, "Without prejudice, I will pay half the repair cost if this ends the dispute." The offer will not usually amount to an admission that the neighbour caused the damage. Simply writing "without prejudice" on an ordinary letter does not automatically make it private or protected. 15. Subject to contract. Subject to contract means that the people are still negotiating and do not intend to make a final, binding agreement yet. For example, a person agrees to buy a house subject to contract. They have reached a provisional agreement, but the sale is not final merely because the estate agent says the offer has been accepted. Either side can walk away at any time before a final, formal document is signed. 16. Statute barred. A claim is statute barred when the legal time allowed for bringing it has expired. For example, you send somebody an invoice for your services and they do not pay. If you wait longer than 6 years to claim your fee, you will lose. Courts also have legal time limits, although these vary according to the type of case. Key time limits include 6 years for general contract and tort actions, 2 years for personal injuries, and 1 year for defamation. Because exceptions can sometimes apply, a person should obtain legal advice promptly rather than assuming that time has already run out, or, more dangerously, assuming it will never run out. 17. Injunction. An injunction is a court order directing someone to do something or to stop doing something. For example, a developer plans to cut down protected trees. A court might grant an injunction temporarily stopping the work until the legal dispute is decided. A prohibitory injunction is where the court orders you to stop doing something. A mandatory injunction is where the court orders you to do something. Ignoring an injunction can have serious consequences. 18. Affidavit. An affidavit is a written statement containing facts that a person swears or solemnly declares are true. For example, if Linda saw a road accident, she might describe what she saw in an affidavit. She must swear she is telling the truth and then sign it in front of a person legally authorized to witness it. An affidavit is regarded as testimonial evidence rather than documentary evidence, and so giving false information in an affidavit is a serious matter and might lead to a charge of perjury. 19. Precedent. A precedent is an earlier court decision that helps judges decide later cases involving similar legal questions. For example, a lawyer is hired by a school worried about an accident that took place on its sport field. The solicitor will search for earlier cases involving the same or very similar facts and can then advise the school based on the outcome of those earlier decisions. Courts also look at earlier decisions to apply the law consistently. Binding precedents must be followed. Persuasive precedents merely help or guide the court. 20. Costs. Costs are the legal expenses involved in dealing with a case. They can include solicitors' and barristers' fees, court charges, and payments for expert evidence. Winning a court case does not mean that every euro spent will be recovered. Out-of-pocket costs are those costs that you actually spend to progress your case. But taxed costs are calculated by a tariff which is not necessarily as much as the actual cost of that item or service. A court may order the losing party to pay some or all of the winner's legal costs, but this is not automatic in every case. I hope this explained things so that you now understand what these commonly used legal words or phrases mean. Take care until next time.